Well, good evening, everyone, and welcome back to AJ103 Criminal Evidence Online. Tonight's lecture is going to be on Chapter 6, and we're going to talk about witnesses, and more so about witness testimony than probably anything else. So there's another chapter down the road where we'll get into things like eyewitness identification and the types of witness identifications, etc. But this evening we're going to focus more on the testimony and the evidentiary nature of witnesses and testimony. And with that being said, again, don't forget about the key terms and the discussion questions that are at both the beginning and the end of each chapter. And those, again, will help you study for your weekly quizzes and also your chapter exams. We're going to have a lot of information to cover, so again, it would be incumbent upon you to read the chapters, paying specific attention to a lot of the examples that they have listed throughout the chapters as well. So let's go ahead and jump right in, and we'll take a very quick look at our featured case that's in the textbook. So in July of 2011, former professional baseball player Roger Clemens was tried for illegal steroid use. Now, the principal evidence against Clemens was the testimony of Andy Pettit and Brian McNamee. Now, each witness had several problems on the stand. And eventually, the jury found Clemens not guilty on all counts. And if you don't know who Roger Clemens is, here's a couple of pictures right here. And you probably recognize him as the 7 Cy Young winner up in the upper left there. And then, of course, when he's in court, actually being sworn in as a witness in the bottom right corner. So how do we apply the law as it relates to witness testimony? And that's one of the big things we're going to cover. Now, in this case, one witness said the likelihood of his testimony being correct was like 50-50. And with that, was that enough, or is that enough to really let somebody testify if they only think they're going to be accurate 50% of the time? And another witness's credibility was attacked for 2 unrelated DUI convictions that really didn't have anything to do with the defendant. So why was that fact admitted? And how did that hurt the person's credibility testifying? And Roger Clemens himself did not testify. And should the jury be allowed to consider this? Now, we talked about this, I think, at length in the last chapter, so you probably already know the answer. But, what do you think? So, our learning objectives this chapter are going to be to define competency in the sense of, do you have to be competent to be a witness? And what is that level of competency? And we're going to learn, hopefully, to explain how to impeach and rehabilitate a witness, meaning to trip them up on the stand, if you will, and get those inconsistencies out or bring forward some information that's not good. But then can we kind of bring back their credibility, as in rehabilitate? And explain how a witness's memory may be refreshed. So if something happened 2 or 3 years ago, what do you use to refresh your memory? Or can you? Or do you just guess? And we're going to list and explain how and about what an expert witness may testify about. We're going to talk a little bit about this thing called the opinion rule and explain what a lay witness may testify about. So I want to start with this, and this is going to take like 4 or 5 minutes, but I think it's well worth the time, and it'll add some context, I believe, to what we're going to talk about. So the first video that I want to show you, and I'll move the screen over, and I'll make sure to So watch closely if you will, and it's going to show a couple of different angles. So you have some officers standing around and a police car speeding away. Now watch another close-up view and look over here this time. When they play this again, you'll see an officer actually get hit by a vehicle and hit the ground. And here's another view from the dash cam of a stolen police car, basically by a suspect that was in custody. And this was police dash cam footage of the James Shaw shooting. Now what I want to show you are a few minutes of the officer's testimony. And this will kind of add some context to some things that we're going to be talking about. And you can take the time to click on these and watch them again. All right, so I'm hoping that this kind of lays a little bit of foundation or groundwork. Now, one of the cool things about that video, and you can look up and see a little bit more on it, and again, I apologize for the time it took away, but it's important because you saw a couple of things. One thing is you probably noticed that when he was speaking, he kept looking in a certain direction. Well, that's because of the diagram. And we talked about photos and diagrams, I think, in a different chapter. And those things are admissible into evidence. And you saw that he had to identify the handgun that was used in the shooting, the fatal shooting of the suspect that stole his police vehicle. And of course, the officer was in fear for his safety, as he stated, and ended up having to use deadly force on the suspect after he stole his car. But with all that aside, you can see that he also, he did identify the gun, which was already entered into evidence earlier. But you can see some of the packaging and the manner in which they question an individual. So I hope this video kind of helped a little bit, at least from a perspective of how witnesses testify and what have you, and more specifically for law enforcement. But here are some myths and some facts as it relates to witnesses. Now, one myth is only people older than 17 or older than 7 can testify. Well, there's no real age limit. They have to be able to understand what they call the duty to tell the truth and communicate that information to the jury. And any witness at a trial can testify about his or her personal opinions. Well, expert opinions are allowed to give, or expert witnesses are allowed to give their opinions. Now, lay witnesses, and we'll learn what those are in a little bit, can only testify about the facts they observed through the 5 senses. And again, we'll kind of get to that. And impeachment means that the witness is not allowed to testify. Well, the jurors, they're going to decide whether to believe a witness or not. And just because somebody might get tripped up or impeached on the stand, it doesn't mean the trial stops and the person is ordered off of the stand. The jurors, remember, they get to decide the credibility of witnesses, of evidence, of testimony, and all of those different things. So just a couple of facts and myths that are out there related to witness testimony. And then if you want to see a little more interesting testimony, you can look at Cato Kalin that was testifying in the O.J. Simpson trial, and kind of the flippant manner, if you will, that he kind of testified as. And there were a lot of people that really didn't believe his testimony. But you can watch that if you want to. So all evidence is introduced at trial by the testimony of a witness. And therefore, the role of a witness in the criminal justice system is very important. And the chapter that we're talking about today is going to address 5 key issues related to trial witnesses. And those are going to be, who is competent to testify, and how the credibility of a witness is attacked, and what could be done if the witness's memory goes away or it's faulty, and what a lay person is allowed to testify about, and how and when expert witnesses are used. So as we look at these 5 key issues, we have to kind of start to ask some questions in our head. And the first one I think that comes to mind is what is this whole competency thing? And while there are 5 key things that we're going to kind of look at, we want to answer that whole thing about competency. Well, every witness who testifies in court must be competent. And in addition to being competent, the witness must possess relevant information. And the standard for competency to testify refers to the person's ability to communicate with the jury. And it is not equivalent to the test used to determine if the defendant is mentally competent to stand trial. So these are 2 different things. Okay? So a competent witness is a person who, 1, understands the duty to tell the truth, and 2, can narrate or tell about the events in question. Now again, remember that the standard of competency for witnesses to testify, it's not equivalent or the same test used to determine if somebody is mentally competent to stand trial. These are kind of two different things. And competence is the first issue addressed when it comes to witnesses. If a person is not competent, he or she will not be allowed to testify. And if the person or the witness is competent, that adversary system, the criminal justice system, begins to unfold, if you will. And the attorney who called the witness asks questions, and opposing counsel should object if the question calls for an answer the witness is not qualified to answer. And the judge rules on those objections. And the jurors who watch this interplay, if you will, have to decide whether they believe the witness and how much weight to give to the testimony. So think about that. The attorney who called the witness to testify, they ask the questions. They get to directly question the person. And opposing counsel should in fact object if the question calls for an answer that maybe the witness is not qualified to answer. And there are people that aren't experts in certain fields, and we'll talk about, again, what a lay person is and what they're allowed to testify to. So if one of the attorneys believes that that witness isn't qualified to answer a question, one of the attorneys can object and say, hey, objection, I don't believe that person is qualified to answer that specific question. Now, that doesn't mean they're incompetent. It means that maybe they don't have the expertise to render a decision or a statement about a certain thing. So I hope that makes sense. And the judge, they're the ones that, again, they rule on the objections. The judge will hear the objections and decide, yes, I think the person is competent to do that, as far as or qualified, if you will, or no, I don't think they're qualified. And the jurors get to see this. And at the end of the day, they have to decide whether they believe the witness and how much weight they're actually going to give to that testimony. So as we continue to talk about the characteristics, if you will, of competent witnesses, well, the first one that comes to mind is this thing called duty to tell the truth. Now, the most common oath administered to witnesses today includes the traditional promise to tell the truth, the whole truth, so help me God. And you've probably heard that on television. Do you promise to tell the truth, the whole truth, and nothing but the truth, so help me God? You've probably heard that. And although each witness must understand the duty to tell the truth, neither the Bible nor swearing by it, if you will, is currently mandatory. Pretty much now you just raise your right hand, and the court clerk will read that admonishment, if you will. Because, I mean, honestly, some people have some religious beliefs against taking an oath on the Bible. And that's discussed back in chapter 4. And what they call an affirmation is also, or can be administered instead of an oath in such cases. But the purpose of the oath or affirmation is to make it very, very clear to a witness that he or she is testifying under penalty of perjury. And if the witness knowingly lies about a material matter, perjury charges may be filed at a later time. And the threat of being punished in this manner is commonly assumed to be sufficient to keep witnesses from lying. So that's why they have you swear under penalty of perjury in, let's say, a deposition hearing, or tell the truth, the whole truth, nothing but the truth, so help me God. That's the swearing in, or the oath, or the affirmation, if you will. And the truth is, however, that prosecutors, I mean, they rarely file perjury charges, but these things can actually happen. Now, in most situations, administering an oath or affirmation is all that is done to really qualify a witness. Now, in the Clemens case, if you read a little bit more, Pettit admitted that he was only 50% sure his memory, regarding the incident was correct. And the judge did not consider this a valid reason to really disqualify him. He just kind of thought, well, okay, the guy thinks he's about 50%, he thinks he'll be right. And he ruled that it was the responsibility basically of the jury to determine what weight to give the testimony. Now, if somebody got up on the stand and said, well, I think this is it, and I'd probably give, about 50% sure that this is correct. What would you decide in your mind? Would you give a lot of credence or credibility to, let's say, that testimony, or maybe you wouldn't? And I think in this particular case, they didn't, because that was pretty damaging. But the judge, again, has the authority to, and his reasoning for this one was, hey, you know what, jury, you get to decide the weight of this person's testimony. So there are some exceptions, though, when we're talking about characteristics of competent witnesses. And there is a common exception to the oath requirement in cases that involve, let's say, children as witnesses. And honestly, I mean, think about it. Young children really do not understand the meaning of the term under penalty of perjury. So the attorney who calls a child as a witness usually has the task of showing the court that the witness knows that he or she is required to tell the truth. And simple kind of right-wrong questioning can be used. So the attorney can ask some questions. Hey, do you know the difference between right and wrong? Yes, I do. Well, can you tell me something that's wrong? Well, I'm not supposed to steal. My mom told me not to do that. I mean, so some simple questions like that can kind of clear that up. And a related problem is posed by the person who perhaps cannot distinguish fact from fantasy. And again, children pose the most frequent problem because young children frequently have very active imaginations, and they may have invisible friends who are quite real to them. And, at the end of the day, again, it is the task of the prosecutor to convince the judge and then later the jury that the child is able to differentiate between fact and fantasy and to testify about events that actually took place. And then finally, there are issues of, senility, somebody that might be getting a little bit senile and may have certain types of mental illness. And these can result in the inability to tell fact from fiction. And the question asked in court to determine if a witness knows what the truth is are not based on medical or psychiatric diagnosis. Factual questions are used in order to show that the potential witness is out of touch with reality. And this is done before the person testifies in the presence of the jury. And I'm sure you can understand why. Because nobody wants to embarrass somebody. So if there are issues of mental illness or senility, these things are brought up before the person is testified in some type of other hearing in front of the judge, where they can determine whether this person has enough wherewithal to testify or not, if you will. So what about that thing that you heard me talk about earlier, this duty to narrate the events? What does that mean? Well, remember, that's one of two things to be a competent witness. Understand the duty to tell the truth, and we kind of went through some of that. And then this ability to narrate. Well, to be a witness, a person must be able to communicate with the judge and jury and must be able to tell about the events in question. And this is called or referred to as the ability to narrate. Now several problems may be raised here. Probably the most obvious is the ability to coherently answer questions. And to do this, the witness must have the ability to understand the question. And severely mentally impaired persons, very young children, and people with certain other types of physical and mental illnesses may not be able to do this. And on a more practical note, what about someone that perhaps that can't speak English very well? Well, this issue is something that can actually be solved pretty quick. So if someone speaks a different language, this is typically solved by using an interpreter or a translator. And if this issue came to mind, the witness would need an interpreter or a translator to understand the questions, and the judge, jury, and the defendant may need a translation of the answers. And a similar problem could arise if somebody, let's say, speaks through sign language only. And again, there are interpreters in order to fix that particular issue. So now that we know, we've kind of talked about those two things, let's continue on with the procedure to establish competency. We kind of know what it is, and we talked about that ability to narrate. Well, how do we establish competency? Well, if there is a question of the witness's competency, a hearing will be held before the person takes the stand. And the procedure, again, is done before testimony. Now, the jury will not be in the courtroom during the session. Questions will be asked of the witness to determine if he or she is competent to testify. And this is called voir dire, which means speak the truth. And the side wishing to call the witness will bear the burden, if you will, of convincing the judge that the person is in fact competent. And opposing counsel will also be allowed to cross-examine. And this screening process is limited to the two key questions of competency: knowing that there is a duty to tell the truth and being able to narrate. And the fact that one side suspects that the witness will commit perjury is not grounds to prevent that person from taking the stand. And neither is the fact that a prospective witness has been diagnosed with some severe mental illness, as long as it doesn't affect his or her ability to narrate. Now, with that in mind, some states do not allow a witness to testify if he or she has previously been convicted of perjury. So that's in some states. And testimony taken during voir dire is not used to prove any of the issues in the case. If the person is found competent, he or she will take the witness stand in the presence of the jury, and direct and cross-examination will proceed just like with any other witnesses. Well, how does an attorney, let's say, impeach a witness or trip them up or show that they're not truthful or whatever we're talking about? It's the word impeachment. Now, one of the key functions of cross-examination is convincing the jurors. Now remember, it's cross-examination, because on direct examination, that's typically where that attorney, let's say it's the prosecutor, direct examination, well, that witness is going to be on your side. It's your witness. So direct examination is based on Let's say the prosecutor calling the prosecution witnesses and the defense calling the defense witnesses. That's direct. Well, cross-examination is where the other side's attorney gets to cross-examine that witness that you called. So one of the key functions of cross-examination is convincing the jurors that they should not believe the other side's witness, and this is called impeachment. Now, I know it kind of sounds horrible. And in some situations, witnesses may be called solely for the purpose of impeaching someone who has already testified, to dispute the story of that witness, if you will. And a witness is impeached by asking questions. If the answers indicate that the witness lacks credibility, then those answers will be emphasized by the opposing attorney during closing arguments. The witness is not asked to leave the witness stand. Remember, I talked about that. Nor is he or she prevented from testifying at future trials. Because the jury, remember, is going to get to weigh the credibility of the testimony. So here's a video clip from one of the forensic technicians, if you will, that were out at the scene of the O.J. Simpson trial collecting some evidence and his subsequent testimony on the stand. And you can see some pretty brutal cross-examination on this particular witness if you want to take the time to watch it. So again, here's the impeachment myth, that the witness is not asked to leave the witness stand, nor is he or she prevented from testifying at future trials. So when we define impeachment, it's attacking the credibility of a witness, and it's typically done during cross-examination. Remember, I went over that. And it can be done by calling another witness. Now, there are 6 main methods of impeachment, and I'm just going to touch on them briefly. I'm not going to go through every single one because they are so lengthy and a lot of information, but you can look through your chapter, and there are also more examples of these as well. And that's where I would like you to focus, would be the examples of each one of these. So bias and prejudice. Well, if a person is biased or prejudiced, it can be inferred that he or she cannot testify objectively. And this includes bias or prejudice towards a defendant, a witness, one of the attorneys, or the police. And bias and prejudice, as used in impeachment, have very broad definitions. Now, on page 149 are some examples of impeachment based on bias. Like hatred could be like another thing. And lesser degrees of animosity toward a party to the case may also cause a witness to distort the facts. And family ties are generally assumed to form strong bonds that would cause a witness to testify more favorably toward one particular relative or whatever. So a lot of these things are held up under this bias or prejudice umbrella. And again, there's a lot of examples. Racial prejudice can also cause a witness to distort the truth. And questions regarding racial bias would only be allowed if the facts of the case indicate that they are relevant. So again, any relationship with the defendant or anyone else in the case that could result in financial impact on the witness can also be used. So again, we have a lot of different things here. So when we talk about bias or prejudice, if a person is biased or prejudiced, it can be inferred that he or she cannot testify objectively. And this includes bias or prejudice towards a defendant, a witness, attorneys, police, and even friends. And it show motivation based on profit or emotion, or show relationship, racial or financial motive. And then here's some examples that again are on page 149 through 151, and there are real examples, if you will, on how these examples play out. So we talked about friendship, allowing friendship to affect testimony, and hatred, personal feelings to affect testimony, and family ties, the strong bonds that could affect testimony, and racial prejudice that allow race to affect testimony, and financial gain, allowing profit or promotion or similar to affect testimony, or motive, because the witness might be getting paid, informants getting deals might in fact impact testimony. So that's the first one, and remember, this is kind of why I'm just going to touch on. Well, the second one would be prior felony convictions. And you're probably wondering, well, what does that really have to kind of do with anything to impeach somebody? Well, the public has a long history of distrusting convicts. And at one time, anyone convicted of a felony was considered untrustworthy and not allowed to testify in court. So they were barred from testifying. And although most states now allow everyone to testify, impeachment is permitted on prior felony convictions, even if the prior crime is totally unrelated to the current case. Now, the defense in the Clemens case, if you recall, was allowed to question Brian McNamee about his 2 prior DUI convictions and show that Kirk Radomski was convicted for dealing drugs and money laundering. And what do you think that brought into the mind of the jury? Well, maybe it's like, hey, these guys got arrested before, so maybe their testimony really isn't that cool, right? So prior convictions may be introduced at trial for 2 very different purposes. They may come in as under other acts of evidence, and we covered that in a prior chapter. I think it was chapter 5. And when used in that manner, they imply that the defendant is guilty because the defendant has done very similar acts in the past. And a separate use of felony convictions to impeach a witness. On cross-examination, opposing counsel can ask about prior felony convictions and thus undermine the credibility of a witness. So the federal rules of evidence allow prior felony convictions to be used to impeach, but give the judge discretion to exclude them. And misdemeanor convictions that involve dishonesty or false statements are also admissible for impeachment. So again, it's a credibility thing. So some questions. What acts are important enough to bring up at trial? Are all crimes past and present linked? Should a jury or judge have all possible information about a witness? And what if a witness is past and the defendants are intertwined? Do the past shared bad acts show the defendant's character? Just questions to think about. So continuing with the list, we're going to talk about prior inconsistent statements. Well, a witness can be impeached if he or she has previously made any statements that are inconsistent with the testimony at trial. And a past statement need not be completely contradict current testimony. But you do need to prove that the past statements were made. So the statement does not have to be or totally contradict the testimony. It merely needs to show that there is a reason to suspect the accuracy of the testimony. And the appropriate procedure is to ask the witness if he or she made a specific statement. The date, the place, and the name of the person to whom the statement was made are also given, so that the witness has a fair chance to recall the event. And if the witness denies making the statement, the judge may allow another witness to be called to testify about the statement in question. And it is misconduct for an attorney to ask a witness about a prior statement unless the statement is believed to, in fact, have been made. And finally, the U.S. Supreme Court has ruled that statements obtained in violation of Miranda may be used to impeach. Okay? The only restriction is that it must have been obtained without coercion. And most states follow that particular rule. And I thought I'd throw that up there. So still under our list, we have bias or prejudice, prior felony conviction, immoral acts, uncharged crimes, prior inconsistent statements. What about inability to observe? And this is kind of a big one. Well, the credibility of a witness is weak if he or she was not able to clearly observe the events in question, and impeachment is used to raise the question. Inability to observe usually has one of the following causes. 1, physical impairment of the witness, or 2, obstruction at the scene, or 3, the witness was too far away to see or hear the events in question. Now, sometimes more than one of these problems arise at the same time. For example, the witness might have a physical impairment like bad eyesight and was also too far away to see clearly. And since a witness can testify about anything observed with the 5 senses, a defect in any of these senses that is relevant to the testimony may be grounds for impeachment. So again, something to just, kind of think about as we're talking about this. And there are a lot of things that can be brought up at trial as it relates to the inability to observe. And then finally, reputation. So can you really impeach somebody because of their reputation, because they were like a bad dude? Well, let's talk about it. Impeachment based on reputation is usually restricted to the trait of honesty, also called truth and veracity. Now, the credibility of a witness is easily diminished if it can be shown that other people believe the witness is basically a liar. And as discussed in Chapter 5, reputation is usually known or shown by the testimony of people who claim to know what the community thinks about a certain person. Now, for impeachment, the question rests on the general reputation of the witness for honesty. And the defense in the Clemens case, if we look at that, called the Yankees' former security director, who testified that Brian McNamee basically had like zero credibility. And so you can see how that usually kind of works. And if you want to look at a case of credibility on the witness stand, this video is pretty short, but take a look at this video, and I think you'll know where I'm coming from. Well, now that we've looked at ways that we can impeach somebody, can we fix that? If you're an attorney, can you rehabilitate somebody and bring them back from after they get like knocked down? Well, the answer is yes, for the most part. So rehabilitation is the restoration of the credibility of a witness. Now, once a witness has been impeached, the side that originally called the witness will try to convince the jury that its witness testified truthfully and should be believed. And attempts to rehabilitate witnesses are done during what we call redirect examination. And sometimes the judge will allow new witnesses to be called to support the credibility of an impeached witness. Now, where impeachment focused on prior criminal conduct, rehabilitation frequently tries to publicize good deeds and if possible, the years of exemplary conduct since the last serious offense are going to be kind of brought forward or emphasized. And sometimes an attorney decides that the best defense is a strong offense, and the witness's unsavory past may be acknowledged during direct examination, so they bring it right out on Front Street. So the impeachment will lack that dynamic effect where the defense attorney gets up and brings it forward. So some attorneys will just say, hey, isn't it true that you did this in your prior, in your earlier years? And that takes the air out of the person's balloon, if you will, or the defense attorney. So you can see again, so it's defined as an attempt to restore credibility of a witness who has been impeached. And there are examples of both of these on page 159 that talk about examples of rehabilitation based on good behavior and examples of rehabilitation based on witnesses currently telling the truth and based on lack of impairment and use of expert witness. These are on page 160. So you'll see a bunch of different examples that you can utilize. So let's talk about corroboration for a little bit. The credibility of a witness is definitely stronger if there is additional evidence to support the witness's testimony. This supporting evidence is called corroboration. And either the testimony of another witness or physical evidence can be used to do this. Now, in the Clemens case, the Yankees massage therapist took the stand and testified that he had not seen acne on Clemens' body. And the fact that acne, a frequent side effect of taking steroids, was not observed, it corroborated Clemens' statement that he really didn't use steroids. So can you see how they used it in the Clemens case? And there are a few situations in which corroboration is mandatory, and one involves the testimony of an accomplice. When one party to the crime testifies against another, there is always the suspicion that this was done to reduce his or her own culpability. Well, I'm going to get a deal, so I'm going to testify against the other guy. So due to this motive, to falsify, if you will, a person cannot be convicted based solely on the testimony of an accomplice. There has to be some type of corroboration. And many states also allow the common law rule that there must be some corroboration in cases of false pretenses. And a few still follow the old rule that required corroboration in rape cases, although this has been highly criticized. Nearly all other crimes can be established solely on the testimony of victims. Well, what about like memory failures? And just kind of throw this up for corroboration is different from cumulative evidence. So remember, I don't want you to get like confused. We remember this, right? It confirms previous testimony by the use of another source. So that's the difference between corroboration and cumulative evidence. So memory, it is not uncommon, especially when there is a long period between the crime and the trial, for a person to forget details of a case. And this includes victims, witnesses to the crime, and you know what? Even police officers. And when this happens, an attempt will be made to refresh the person's memory, and this can be done either before taking the witness stand or by asking the appropriate questions during direct or even cross-examination. And the basic rule is that anything can be used to refresh memories. Witnesses must, however, be able to testify from memory and not merely memorize material used to refresh their memory. During cross-examination, the opposing attorney will attempt to point out, of course, that the testimony is not accurate. And it may also be pointed out that the witness was coached, testimony was memorized, or the attorney told the witness what to say. Now, the most common thing used is the report written about the event, although almost anything can be used to refresh a witness's testimony. The original report written by an officer can be used, so can notes jotted down in a field notebook. And for this reason, it is important that police officers take accurate notes and retain them until all possibility of a trial or retrial has already passed. So far we have described what is called the present memory refreshed area. And once the witness recalls the events in question, he or she can testify. Now, sometimes the attempt to refresh that memory fails, and when this happens, it may still be possible to introduce reports written near the time of the event in question based on what we call the past recollection recorded exception to the hearsay rule. Wow, that's kind of a lot of stuff. Now, the key to using this past recollection recorded issue is that an accurate report was made when the events were fresh in the witness's memory. Now, the rule does not set a maximum length of time. The jury gets to make the decision or decide after listening to the direct and cross-examination. So there are some exceptions that are listed here as well. The statements that would be admitted if made at trial today. Currently, witnesses cannot accurately recall. The report was made when the memory was fresh and accurate, and witnesses can testify that the record was made, and witnesses can testify that a report was accurate. So those are all the things that fall in here. But what if you can't find the witness, or the witness is like unavailable? Well, sometimes a witness is not available to testify at trial. And this can happen for a bunch of different reasons. Death, relocation, or the witness has gone into hiding. Now, under the hearsay rule exception for former testimony, statements made under oath at a prior court hearing in the same case may be introduced at trial if the witness is not available to testify at the subsequent trial or hearing. And this is discussed a little, we'll talk about it more in Chapter 9. Now, many states have established other procedures to preserve testimony if it is believed that a material witness may be unavailable at trial. And some allow sworn testimony to be recorded on videotape to be used later at trial. Others take sworn statements in a manner similar to like a deposition that are taken during discovery in civil cases. So you can see there are some things that we can do that will allow us to utilize testimony of unavailable witnesses. Well, now remember I talked about lay witnesses. Well, a lay witness is a person who observed an event that is relevant to the case on trial. And lay witnesses are allowed to offer or to testify about any relevant event that was observed with one or more of the five senses. And this would be sight, hearing, smell, taste, and touch. And you can look under the Federal Rules of Evidence 701 that talk about the opinion testimony by lay witnesses. So they are, this allows common opinions based on everyday experiences. And examples could be identification of parties or identification of, let's say, voices, or what they believe the speed of a car to have been, or an emotional state of a party observed. And these are things that, again, lay witnesses are allowed to testify to. And on page 166, there's another list that adds a few more things about the wide variety of lay opinions that may actually be admissible. And again, another one that's interesting would be somebody's handwriting. You could testify as to whether or not you recognize somebody's handwriting. And then the opposite of the lay witness would be like expert testimony. And I have a couple of videos that I'm not going to play, but I want you to watch. So watch the expert testimony video here, and then watch these two videos and see how they come together as far as expert testimony goes, because you'll see an expert talk about this particular shooting and try to bring in expert testimony. And I'm not going to tell you whether it's defense or prosecution. Well, expert witnesses are called to help the jury understand the evidence and are only allowed if the facts cannot be understood by the jurors without their help. And there are a wide variety of specialists or specialties in which experts can be useful at trial, and some require extensive education, whereas others are based on just specialized training and experience. And expert testimony cannot invade issues that the judge or jury is required to decide. And this means that they usually may not state conclusions on legal issues. So, for example, a psychiatrist may state a diagnosis like paranoid schizophrenia, but in most states, he or she is not allowed to testify that a person is criminally insane. Does that make sense? So the psychiatrist can talk about the diagnosis, but they can't say, hey, you know what, the person's crazy. Now, both the prosecution and defense called expert witnesses in the Clemens case, and the prosecution experts conducted tests and identified the presence of steroids and DNA. And the defense did not dispute these test results. Instead, the defense experts focused on possible contamination caused by storing medical waste for more than one individual in a beer can. And they also alleged that McNamee, in this case, fabricated evidence before giving the beer can to authorities. So again, and in order for expert testimony to be used, there has to be a foundation laid for expert witnesses. So again, in order to use an expert witness at trial, a foundation has to be laid that establishes three different things. One being that the jury needs the help of an expert. Two, that there is a recognized area of expertise that applies. And three, that a person called to testify has the appropriate background to qualify as an expert. And the test that they use would be the Frye-Daubert test. And the Frye-Daubert issue is considered first if either side raises the issue. And in most cases, the tests that are used are well established and do not require a separate hearing. And this was the case at the Clemens trial. So you can see traditionally this was subject to the Frye standard, and now the Daubert standard controls the area, if you will, of expert witness testimony. And I'll let you take the time to look at this particular case. And what I've done is I've broken it down, the Frye-Daubert. So again, traditionally, expert testimony was under, or subject to the Frye standard. And now it's the Daubert standard that controls. So what I've done, and here's the case law that changed that. This is Frye versus United States. And here's the Frye standard. And I'll let you read it, and it talks about what the standard is. And I think later on, the Daubert standard is going to come into play. So under 702 of the Federal Rules of Evidence, the same thing for an expert witness, we must lay a foundation before testimony. The expert must explain the methods that were used, and they must show how the methods apply to current facts. And the test that's used now would be that Daubert standard, and it's based on this case, Daubert versus Merrill Dow Pharmaceuticals. And here are the facts of the Daubert case. So the reason I'm going over it a little bit quickly is that one, it'll give you a chance to read the two cases, and two, we're kind of running out of time, so I want to make sure that we get through this. Now, I also put up a comparison slide that shows the difference between the Frye standard and the Daubert standard when it comes to expert testimony. So what are some examples of expert testimony? Well, insanity could be one. Ballistics could be another. And blood and tissue matching could be another. Use of force could be another. So these are all the different things that could come into play, and there are several more. So as we end here, let's ask a couple of questions. Now, both the Daubert and Frye standard require scientific judgment, but is a judge trained to make these decisions? And has science gotten too complex for the layperson to understand? And when does probability become high enough to actually become true? Now, in the Clemens case, it was 1 in 449. And is that enough to convict? Well, apparently it wasn't. So remember, experts are also subjected to voir dire to prove their qualifications. So they'll be asked a series of different questions in order to show proof of qualifications. And then finally, kind of as I said a minute ago, some examples of expert testimony would be insanity or ballistics or blood and tissue. So with that being said, we just went over the 60-minute mark, so sorry about that. If you have any questions, feel free to post them on the discussion board. If you don't want to post them there, you can send me an email. And again, don't forget the resources at the beginning of the chapter and at the end of the chapter. But more than that, look at the examples that are listed in the textbook. Those really help you add context to a lot of these terms and things that we're talking about. So with that being said, until next time.